case to come before the court is in re FD, and both sides will have 15 minutes, and the appellant may reserve up to 5 minutes. Now, you know, you've both been to this court many times, you know that we're videotaping and recording it for YouTube, and you cannot mention, please, the names of children or the names of victims. Other than that, we're ready to proceed. Just let me know how much time we're reserved.
Thank you, Your Honors. May it please the court, Attorney Angie Killey on behalf of the appellant father, Neil McNeil. I would like to reserve 5 minutes for rebuttal, please.
Thank you.
The issue for the court's consideration today is whether or not the trial court erred in making a finding that permanent custody was in the best interest of this child. And I'm going to urge this court to say yes to that. We have a I know that mother raised a lot of issues that I am not going to touch on because father's position, quite frankly, is that mother's, as it relates to mother, it would have been in the child's best interest. She did not complete any of the requirements for case plan, didn't even actively participate in the case after the second time that the child was removed from a placement. It's father's circumstances that we feel that the trial court erred in. The prosecutor is right in the brief. The reality of the situation is 1222 was met. This child was in the custody of the agency off and on for way too long, is the reality of the situation. However, we feel that finding permanent custody is contrary to his best interest because he does have a parent, a father, who would be in a position potentially to have taken him and had him, and they have a loving relationship. I recognize that there are rules in place, and I know the state brought up that there was no filing for an extension of time, a 6-month extension. And I can't read counsel's mind, but I have to anticipate that that didn't happen because there was no more time under the law for that. This case was passed 1 year, passed 2 years by the time that it came to the permanent custody trial, so I don't know that that would have been any better than him making a motion to give the court to give him a little bit more time in order to see where he was at. And I think in reviewing the testimony, the caseworker and even in Appellee's brief acknowledged the father, he's really a success story for somebody who was in prison. He served a substantial amount of time in the institution, but during that time, as opposed to most people who are learning ways to be better criminals or thinking that their life has come to an end, he used that time to write a book, to counsel other inmates, to help them to deal with their circumstances in their lives, to maintain a relationship with his son from his birth the entire time that he was in custody. They developed a bond, and his child had a consistency with his father who was incarcerated. He was the most stable person in this child's life for his entire life and continues to be. His circumstances were such that the timing was that he was released from prison right before this case went to trial. And if that wouldn't have been the exact timing of this case, even if we had been looking at a couple of months, I submit to you that we would have a different result. Because I think the caseworker made it quite clear that she felt that father would be a viable option for this child, but we don't have any more time.
So she did not make a recommendation to place the child with father at that time?
She did not. I think the reoccurring theme through the recommendations in this trial from the agency, from the court, from the GAL was, we don't have any time, we don't have any time, we don't have any time. And that's what it kept boiling down to. And I think at one point in the state's brief, she said that I'm asking for like a bright line rule to say that it's always in a child's best interest to be with a parent as opposed to an institutional placement. And that's not really accurate what we're saying here. And the reality is, bright line rules sometimes make bad law. We have bad resolutions. And I think this is a situation where anybody can look at this and say, how can it be in this child's best interest? All you ever hear is, this child needs permanence. Well, he's not getting permanence. Just because he's placed in the permanent custody of CSB, he has no foster placement, no viable relatives outside of his father, nobody who's interested in taking him. He had been in an institution for a year at the tender age of 9 when this case came to trial. This resolution doesn't give him permanence. It doesn't serve his best interest. His best interest would be served by allowing even a little bit more time to be able to review whether or not father really did exactly what he said he was going to do. For being out of prison for what, like 2 weeks, I think, when this case went to trial. He already had a job. He was working his way out of his transitional housing, looking for an apartment. He had the ability to build a life, and he had the relationship with the child. And the state mentioned that this child has some needs, but there's nothing to indicate that father wouldn't be willing to work with a counselor in order to build that. And I realize that we can't look outside of the record, but the reality is, as I speak to this gentleman while this case is pending, he's done it. He's still doing everything that he would have needed to do in order to have this child. And now, with this decision, in the eyes of the law, he would be a stranger. So it's not like he'd even be in a position to attempt to adopt his child. And when you look at the case law, I know the trial court and this court often say this is, a firm rule, that we have this amount of time, we can't go any further. But I think what my position would be is, I don't know if that's necessarily true. Because if you look at the case law, and I apologize, but this has been going through my head for months now, so of course I'm thinking further than when I wrote my brief. But if you look at case law, even from this court, there have been instances where the parent has challenged that 2-year time frame and said, oh, the agency didn't bring this to trial until 2 years and 2 months, so you have to dismiss. And appellate courts, including this one, say, well, I don't think it's meant to be quite that bright line where we have to put a child back into a potentially abusive situation simply because a statutory timeline was missed. There's extensions of this timeline all over the place right now because of COVID, with everything being pushed out and extended and cases going longer.
I appreciate it, but your appellate brief simply saying it's against the manifest way, basically.
Because it's contrary to his best interest.
And your appeal did not involve a request in any way that measure should have been continued by the trial court or not, and that's it.
Well, I think, no, because I think that the finding first has to be that it's contrary to his best interest. And I guess where I'm going is there is a potential for this to continue to be reviewed with that additional time. Should it be reversed? It's contrary to his best interest because...
I understand the argument is why the court perhaps should have done that, whether they should have or not, and whether that issue is before us. It's unfortunately not before us because you haven't raised it yet on appeal. You're raising it today and giving the state a chance to respond to the argument. In all due respect, why wasn't there continued? I appreciate as a practitioner, you get involved in the case, you file your brief,
Correct.
you think about it for a while, and you think, you know what, maybe this was the best thing to happen.
And I
but
guess
that's not what you filed to give the state an opportunity to respond to that.
and I appreciate that. I suppose I would be inclined to say that part of the argument in the brief is that additional time would have, that there should be
And that's
some
fair.
exception.
You that issue, I think.
Because she even responded to that with saying that I was asking for a bright line rule, and I suppose what I'm saying is I'm not. I'm asking for.
So it wasn't a separate assignment of error, but you're saying at least you raised the issue to some degree.
I think so, yes, because the argument is part of this assignment of error, at least the basis, and yes, I am expanding upon it a little bit, but it is one of those situations where I just feel like this rule, this analysis, all falls back on whether or not, this child has a permanent resolution, as if there's no other option. And in this instance, I think that it's clearly contrary to his best interest to be placed in the permanent custody of an agency when he has no permanent options with the agency.
There were no, not necessarily dispositive, but I don't see that there are specific case plan requirements for your client to undergo other than to kind of build a relationship. Is that fair? Was he ordered to get housing in a case plan, ordered to be in any kind of treatment for anything?
He was not, because he was incarcerated when the case plan was put together. But my recollection, and I apologize, I can't give you a page number off the top of my head, but my recollection is that there was testimony from the caseworker that father had done everything in prison that she would have asked him to do as part of a case plan in order for him to have been coming into compliance. What she said, I believe on more than one occasion, was all he would need to do is his separate housing.
Did the guardian express any concerns about father and the guardian's testimony at trial?
I don't recall anybody having any concerns with father other than the simple fact that he had just gotten out of prison.
But the guardian's recommendations were kind of yours expressing, gee whiz, I wish we had more time. I can't at this point indicate that the trial could wait for long.
Right, I feel like it was a recommendation by both the agency and the GAL that this is in the best interest of this child by default, because they felt like they had no other option at that point in time as a result feel should be as bright line when they don't serve the best interest. And I think that best interest is where this court can step in and consider and say, you know what, no, this is not in this child's best interest. We need to look for an alternative disposition. Goes back to the trial court, and then they can argue about whether or not a placement is viable or not. Obviously, we can't do that without having additional facts in front of us, but, I mean, they do have to prove by clear and convincing evidence, and I struggle with the idea that clear and convincing evidence is something that's in a child's best interest is proven simply by the fact that there's no other alternative.
Counsel, your time is up. Well, you can continue if you want, but your time is already started at your rebuttal.
If somebody has a question, I will answer it, otherwise I will stop.
Okay, thank you.
Good morning, may it please the court, I'm Jacqueline Accordion on behalf of Children's Services, the appellee in this matter. My remarks are likely to be very brief. This is essentially a fact-based case concerning what is in the best interest of this child. I would remind the court that the best interest of the child is determined based on clear and convincing evidence, not potential. And that is essentially what father is relying on in this case, is that his argument is that he potentially could have been at a suitable home for this child, but if he had been given sufficient time. However, I would just bring up a couple of facts. Even though there's no dispute that father made laudable efforts while he was in prison, to do essentially, again, what the caseworker would have said would have been in his case plan. By the time this case came for a permanent custody trial, 5 years into this case, father had been out of prison in a halfway house for 6 days. So for less than actually a week. And his testimony was that even though he was applying to be eventually put into a home treatment or a home monitoring situation, where he would, again, he was looking for an apartment. He thought he could easily get a job because he'd become a licensed forklift driver. He didn't have that in hand, didn't have an apartment in hand, and it could have been up to 9 months after the permanent custody trial when he might have been able to be in a home monitoring situation where he could have taken care of the child.
Well, even if he didn't get a job right away, he had $7,000 in savings, which is absolutely phenomenal. Somebody coming out of prison, it's absolutely phenomenal. I've never even heard that in any of the Children's Services Board cases that have been in front of me in 25 years, that somebody would have that kind of money saved up to prepare for housing for their child.
And again, his efforts are laudable, and this case doesn't actually hinge on whether he had a job or not. It does hinge on whether he would have been able to be a good home for this child when the child needed it. And part of the testimony was that this child was in a residential treatment program. This child, he has needs. His needs are pretty extreme. This is a 10-year-old child who was described as improving because the staff at the residential treatment program wasn't having to physically restrain him as often as they were when he came into treatment. He has 3 diagnoses, 2 of which are very serious. In addition to ADHD, he has disruptive mood dysregulation disorder and a conduct disorder. And the conduct disorder itself is described as a condition that some boys require years of treatment for that.
Was there testimony presented that there is absolutely no way that he would be able, no chance that he would be able to succeed in a home setting period without being institutionalized? Because I know he came from a home setting to begin with.
No, that was part of the purpose of the treatment, was that and at the time when the permanent custody trial took place, he was at the cusp of starting the 4th phase of treatment that was hoped that he would, if he completed that successfully, that he would be able to go into a home setting. However, the testimony was that whoever provided him with that home setting was going to have to require a lot of training in order to deal with the significant problems that this child has, and to monitor his medications, of which there are at least 3. Just to give the court an idea, even in the residential treatment, he was going through 2.5 hours of counseling, intensive group counseling per day for 5 days a week. In addition, one-on-one counseling 2 or 3 days a week. So that's an extensive amount of treatment that this child was undergoing. And it was hoped that in a couple of months, maybe a month or 2, the child would have been ready to graduate from the outpatient treatment, or the inpatient treatment, I'm sorry, and go into a home setting. However, two months from the time of the permanent custody trial still overlapped a time when father still would probably not be in a home monitoring setting himself.
Well, we don't know that, so what about father's argument, App.No's argument, that the matter should have been continued in some respect, we could find out what was going on before he made the determination for this child?
I'm sorry, can you repeat that again?
I'll try.
Okay.
And how about if I don't repeat that exactly, but I try to repeat it a little bit better. What appellant's arguing here to me is that, and I think it's argued today at hearing rather than necessarily in their brief, but what should have happened in this matter is there should have been a continuance granted. So we could have seen exactly where father and child were in the future, so that father had more time to develop a relationship. We saw when father would have a house, if child was ready to leave at that point in time with father in a house or not. What about the argument the matter should have been continued rather than decided the day it was?
Well, I don't recall that there was a written motion for a 6-month.
I think father agreed there was never a motion filed to continue, to be fair.
Okay. As I was going to say, I don't believe there was a written one filed. I think there was an oral request by father, just hold on to this case for a while and allow me to see if I can meet the requirements.
At the hearing.
Correct, at the hearing. The consensus with the caseworker and the guardian ad litem was, look, this child has been in care for now 5 years, since he was 6 years old. Even prior to that, he was pretty much under the agency's aegis in some respect, on and off from the time he was born. And so the idea was that the need of permanency for this child, whether it's in the agency's custody or adoption, was so high because of all the chaos that this child had been through, that was their concern, that this might, essentially we were out of time for this child, and they were concerned that even despite the laudable efforts that father had made, they were concerned that he just wasn't yet ready to provide this significant stability that this child requires.
And there was no testimony that this child was, anybody who was waiting in the wings for adoption probably wouldn't even be adopted, right?
Not at the time of the trial. What was in the record was that if once he completed his inpatient treatment, if once he got to that stage where he could be allowed to be in a home care setting, he needed to be in a therapeutic setting nonetheless, whether that be in a therapeutic adoptive home or a therapeutic foster home. But he needed to be in a home where he would receive significant care. Now, just because I'm going to briefly touch upon mother's arguments, I understand her counsel is not here to raise her arguments, but the agency obviously disagrees with her contention that there was a cutoff in the juvenile court's jurisdiction. They've explained that in a brief. This child is subject to the court's continuing jurisdiction, but also regarding mother's arguments concerning the best interest of the child. Sadly, mother deteriorated from the time that we were before this court concerning this child and the permanent custody trial, to the point where her claimed requests for new counsel were so inchoate and so vague. They were basically, how the trial court described it, is basically she was just yelling that she was unhappy with her counsel. So that was not an actual, a request for new counsel that the trial court had enough to act upon. And in fact, it would have been an error for the trial court to have halted the trial and allowed her to proceed without counsel. So unless there are other questions from the panel, the agency would respectfully ask that you affirm this decision.
Thank you.
Thank you.
You have your 5 minutes. Thank you.
All right, thank you. Well, thank you both for your presentations and the arguments in regard to this case today. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as we will release it on the Supreme Court website. The next